Hearing an appeal of Process Industry Development Limited against the Federal Republic of Nigeria.
Yes, Mr. Villa.
My Lords, my Lady, I appear for the Appellant Process and Industrial Developments, or P&ID, together with my learned friends Mr. Bacon and Mr. Hosky. The Respondent, Nigeria, is represented by my learned friends Mr. Carpenter and Mr. Ford. We did notify the Court, my Lords, my Lady, that we would like to divide our submissions between the three of us, and I hope that's acceptable.
Yes, of course.
I'm grateful. I'll explain in a moment the contributions that each of us is going to make after some brief introductory observations. The issue on this appeal is, in broad and neutral terms, what principle should a court apply when it is asked to determine the currency of a costs order? There is currently no consistent approach to that question, and it is an important issue in this case, at least, and that is illustrated graphically in both senses of the word in the Statement of Facts at page 46, which is volume 1 of the bundle, tab 4, page 46.
I should tell you, we do have a key documents bundle which has the judgments below and the written cases, but otherwise we're working on an electronic bundle, so volume numbers won't help us. What we need is the electronic page.
That's very helpful, my Lord. Page 46.
It's 46 of the key documents bundle as well. Yeah.
It's page 46 of the main bundle, and it's page 8 of the key documents. Is it?
Yes, well, it's labelled 46 in the bottom right-hand margin.
It should be a page with a chart on it.
Yes.
Yes, indeed.
I'm grateful. Now, for context, as the Court knows, Nigeria was the successful party at the trial and was awarded its costs of the proceedings in the usual way. Those costs are claimed in the sum of £44 million sterling odd. And of that sum, broadly speaking, 10 million has been paid, 10 million has been ordered to be paid but is stayed pending this appeal, and the balance is the subject of detailed assessment proceedings. It was common ground before both courts below that Nigeria transacts predominantly in its own currency, naira, and that it paid its costs by exchanging naira for sterling on a regular basis. For most of the proceedings, the naira was pegged to the dollar, and in that period, as we see from the chart, it bobbed along at around 500 to the pound. But in June 2023, which was after the trial but before the judgment, the naira was unpegged from the dollar by Nigeria's central bank and began to depreciate quite dramatically. And it is now sitting somewhere around 2,100 to the pound. So as against sterling, it's worth roughly a quarter of what it was at the time of the trial. The consequence of that is set out in the table at the end of our written case, page 94. The total costs of 44 million were paid at a cost to Nigeria of around 25 billion naira, whereas at today's rates, they are equivalent to 95 billion naira. So if Nigeria were to recover its costs in sterling and convert them back to naira, it would end up making a profit or windfall of 70 billion naira.
But with the same buying power?
The same buying power.
The difficulty with the windfall argument is the same difficulty that we faced back in 1967 when the Prime Minister said the pound in your pocket wasn't affected by devaluation. It jolly well was. And I mean, last year Nigeria had an inflation rate of almost 35%. So you're not comparing like with like when you compare naira today with naira 3 years ago.
Absolutely, Maura, and I entirely accept that.
Well, where's the windfall then?
With respect, that's entirely the point, that the whole question of what is the appropriate currency, the whole objective of ordering costs or damages, as the case may be, in the relevant currency is that is the currency in which the loss was felt. Now, if that currency has become less valuable over time, then so be it. That is just an extraneous circumstance that the court does not have regard to.
And similarly, if it's become more valuable, that's just tough for the paying party.
Exactly, my lord. Yes.
I see.
Yeah. And that is the dispute between us, is essentially as to whether that kind of windfall, and I accept it's only a windfall in naira terms, but that kind of windfall, or it could be a shortfall if the facts were reversed and the naira had
I
appreciated.
don't understand what you mean by a windfall in naira terms. Are you suggesting there is any windfall at all? The naira that they get is worth exactly the same as what they had to pay.
Well, it depends what your lordship means by worth. I mean, as against sterling, of course, that's correct.
But I don't understand the concept of a windfall. If you could just explain.
Yes, so very simply, if one takes a particular currency and one has spent 25 million of that currency and receives back 95 million or billion, then that
the 95 billion is exactly the same as what you spent.
Well, with respect, my lord, it's not the same. It may be worth the same as against sterling, but it is not the same. And one has to take a currency and select that as the appropriate currency. And then, by definition, recovering more in that currency than one has spent is a windfall or a profit in terms of that currency.
It's common ground that Nigeria was billed and paid its English legal costs in sterling.
Yes, that's right.
Thank you.
Now, the dispute between us, as I say, is whether that kind of, let's use a neutral term, difference between what was spent and what is received back is capable of having any relevance when the court makes a costs order. And we submit that, for the reasons I'll develop, that it is relevant. And fundamentally, our argument consists of 4 propositions, 3 of which are not in dispute and can't seriously be in dispute. I'll summarise what those are. First, the court may make an order for costs in any currency as a matter of jurisdiction, just as it can make an order for the payment of any other sum of money in any currency. Secondly, when a court awards damages, it will do so in the currency which most appropriately or justly compensates the claimant for its loss. Or, expressing the same idea in different words, the currency which most truly reflects the loss that the claimant has suffered. And that is not necessarily the currency in which the loss was immediately incurred, but will often be the claimant's own currency. Thirdly, both awards of damages and orders for costs are compensatory in nature. The purpose of a costs order is to compensate the receiving party for the costs of the litigation, to the extent the court, in its discretion, decides it should be compensated. And fourthly, we submit it follows from all of that the approach to determining the currency of a costs order should in principle be the same as or analogous to the approach to determining the currency of other kinds of compensatory order. In both cases, the order should be made in the currency in which it is most appropriate to compensate the receiving party. And that is the currency in which the relevant loss or expenditure or costs, as the case may be, is truly felt or borne.
Did you say that the third ground was common ground?
It is, yes, I think it's not.
I should have thought a lot of the debate will actually focus round that third ground.
Well, what I would say to that, my lord, is this, that I don't think it's disputed that in a broad sense costs are compensatory. I think what the respondent might say is that glosses over, that formulation glosses over the question of what exactly is being compensated and whether it's loss or
I
life.
think it's whether compensation means the same in the context of costs as it does in the context of damages for loss.
Well, my answer to that would be it does have the same meaning. Compensation only really has one meaning. It's making good something that has been lost, essentially. Now, how one does compensate and the mechanics by which it's done and the rules that govern it, its assessments may be different in different contexts. But I think the fundamental point that the purpose of a cost order is to give the receiving party back something towards what it is spent or is liable to spend. I have no difficulty with that formulation on the litigation. I don't think that can...
Well, I think it's really the question, is it concerned with the reimbursement of costs to the extent that the costs regime permits, or is it concerned with compensation for loss?
Yeah.
Well, I mean, in a typical case, there'll be no difference in the sense there'll be no difference between what is a party is liable to spend and what it actually does spend. I mean, this is at the heart of the Court of Appeals.
It is. I mean, that's why I was curious to hear that you thought that your third proposition was common ground.
Well, I think it is common ground that a cost order is compensatory. The point on which the Court of Appeal based itself was that it compensates for a liability and not for a loss. And of course, I'm going to deal with that distinction. Now, the analysis I've set out is consistent with and supported by the one decision before this case in which the question has been directly addressed, and that's the decision of Mr. John Kimball sitting as a deputy judge in the case of Cathay Pacific and Lufthansa. And he expressed the position in exactly the way I described, namely that the court should identify the currency which most truly reflects the loss that the receiving party has suffered. And we submit that that is correct for the reasons I'll develop, and that it points unambiguously to an award expressed in naira. We also submit that if the court were not to accept that proposition, it would need to have identified some alternative and better principle to govern this situation. And in our submission, there is no alternative, satisfactory alternative principle. And certainly Nigeria, in our submission, has not articulated any clear or coherent alternative principle which could sensibly apply. And the principle for which Nigeria contends, as we understand it, is set out in its written case, paragraph 2 on page 96. There it's asserted that, quote, the key and applicable legal principle is that a party that has been invoiced and paid its cost in sterling is entitled to have those costs assessed and paid in sterling. So that's the rival proposition. But with respect, one only has to consider that for a moment to realise it cannot be the key principle, or we would say any sort of underlying principle. It would, of course, supply the result that Nigeria wants to achieve in this case. But as a general principle, it raises more questions than it answers. For example, what happens if the costs are invoiced in sterling but paid in another currency? Or conversely, if they're invoiced in another currency and paid in sterling? Nigeria's principle will not tell you the answers to those questions.
Well, I presume that the answer would be the liability. So this is an indemnity against a liability. And so the question is, what amount, in what currency are you liable to pay the costs? So the currency in which you pay them may not be as significant, but this is an indemnity against a liability. If the costs are calculated in sterling and invoiced in sterling, that's a liability in sterling, and there's an indemnity against those costs.
Well, that may be right. It isn't, as we'll see, what they consistently say, but that would certainly be consistent with how the Court of Appeal approached it, and that may be the answer that is offered. There are really, in my submission, only two realistic alternatives. One is the one that your Lordship gave, which is the currency of the liability. The other is to order costs in sterling, and those are really the rival candidates. And for the reasons I'll explain, neither of those is ultimately satisfactory as compared with the currency in which the costs were truly felt. Just to go back to Nigeria's principle, what happens again if the costs are invoiced and paid not in sterling but in a foreign currency? That of course, could be a case for ordering the currency of the liability.
Well, I think if the costs are calculated in sterling, and it really matters not whether the solicitor then says, by the way, I want to be paid in a foreign currency, or converts it into a foreign currency. The underlying liability is a liability calculated in sterling.
Well, the liability may have been calculated in sterling, but I think once one moves away from what the liability actually is and the currency in which it's actually expressed and starts entertaining the idea that despite being expressed in sterling, the liability is actually in another currency, it becomes quite complicated and uncertain. But, my Lord, I would also point out that Nigeria's principle is framed in terms of the receiving party being, quote, entitled to have its costs assessed in sterling. So that suggests that the receiving party has a right of election to have its cost assessed either in sterling or in some other currency, whichever is more valuable at the time.
I wonder, I mean, the whole premise here seems to be that costs, an award of costs is some form of relief. And I wonder about that. The costs are normally don't reflect what has the expense actually incurred by a party. It's a figure. The award of costs is made in accordance with rules of court, which in most cases result in the person receiving substantially less than the expense that they've actually incurred, because the purpose of the rules is not to compensate, or at least that's certainly not the only, or perhaps even the primary purpose, but to enable them to recover as an award of costs a figure which is restricted, first of all, by the court's desire to keep some control over the cost of litigation so that it's within reasonable bounds, and also to secure access to justice so far as that could be obstructed by excessive amounts of costs. So, for example, if you like, the one end of the spectrum is the Aarhus Convention and cost capping in environmental cases, where, in the interests of access to justice in that category of case, the successful party may recover only a tiny fraction of what they have actually spent.
My Lord, absolutely. I mean, the court has a discretion. I'll come to the special statutory regimes, but the general position is that the court has a discretion to award a party its cost. Of course, it usually awards the successful party its costs, and it has a discretion to make an order for costs and as to the proportion of the costs that will be recovered.
Yes, so I'm querying the premise that this is a form of compensatory relief.
My Lord, yes, and it is, because when the court makes an order for costs, of course the amount which is recovered is restricted in the sense that the party will only recover the costs insofar as they are reasonable and usually proportionate. And in practice, that means that the party will not recover 100% of its costs. But when the court does make an order for costs, to the extent it does so, those costs compensate the party to the extent that the order is made for the costs of the litigation. That is their purpose. Now, of course, there are special regimes which cut across that in quite drastic ways sometimes, and in some cases either no costs or very limited costs are recoverable. There it is possible to say that the costs are only compensatory in a very tokenistic sense, because there's no real relationship between what is awarded and what is actually incurred. Nonetheless, the purpose and effect of a costs order where it is made is to compensate the party for its costs to the extent that the court has made the order.
Yeah, and I mean, in practice, costs are often assessed summarily by the judge, and this court doesn't normally grant permission to appeal on questions of costs. And I think those those practices reflect the fact that that the award isn't a matter of relief, but rather something to be dealt with in a fairly summary way, so that it doesn't turn into what would really be a form of satellite litigation.
Well, indeed, and I respectfully understand and agree with that. But where the court makes a costs order and the parties ask it to make an order in different currencies, nonetheless, in most cases, of course, it will not make an enormous difference. In this case, it does. And the court needs to decide what is the principle to apply in that situation. And there are, we've identified so far at least 3 rival principles. In my submission is that it's the currency in which the costs are truly borne or felt, analogously with the principle in relation to damages.
But what about the point that Lord Hodge raised? I mean, the stage of the argument that you're focusing on is a comparison between rates of exchange on different dates. But the real value of a currency isn't reflected solely in an exchange rate, but also in the purchasing power of the currency on the different dates.
Well, I respectfully suggest that that is not the right approach, but any more in relation to cost than it would be in relation to damages. And in relation to damages, it's certainly irrelevant to take into account relative value between currencies, because that, in a sense, turns the principle or sets the principle at naught, or turns it on its head, in the sense that one is then not looking at the currency in which the award was felt. The whole, and we'll look at this, but the whole point of the principle in relation to damages, where it's clearly established, is that one looks at the currency in which the loss was sustained. And if a party spends its usual currency to discharge a liability, then that is the currency in which it is likely to recover compensation, regardless of the fact that by the time of the trial, it's now worth very little compared to other currencies. And that is precisely the point of this principle. It's precisely why these disputes arise. Now, having made those slightly long introductory remarks, I'm going to try and organise my submissions as follows. First, very briefly, to identify what the salient facts are and show the court the judgment of Mr. Justice Knowles at first instance. Then to take the court to the main authorities we rely on in support of our core proposition. And in that context, to address the 2 main arguments, as we see it, of principle that are made on behalf of Nigeria. That's first, the argument that costs are different from damages, and secondly, the argument based on the indemnity principle, which essentially reflects the Court of Appeal's reasoning. And I'll explain why we say the Court of Appeal's analysis is wrong. And then finally, I will come back to the point that I trailed a moment ago. That's why our approach is to be preferred not only to the Court of Appeal's approach, but also to the only other realistic alternative, which is to award costs in sterling. I hope that will take me to around 75 minutes. I'll then hand the baton to Mr. Bacon, who will address the practical and policy-based arguments that Nigeria invokes. And finally, Mr. Hoskins will explain the consequences that follow in terms of the disposal of the appeal if we are right on the central question of principle. So first, very briefly, the facts. It's convenient to start in the Court of Appeal's judgment at paragraph 11, it's page 153. First, the court notes that we relied on a letter from Nigeria's solicitors about 2 weeks before the consequentials hearing on the 8th of December 2023. The letter itself, we don't need to go to it, but it's at page 316. And that stated that Nigeria had paid invoices relating to its costs on a regular basis. As the Federal Republic of Nigeria, it's self-evident that our client primarily transacts in naira, and indeed we understand it's regularly exchanged naira for sterling on the foreign exchange market to discharge costs and liabilities in relation to these proceedings. There was then an exchange of correspondence, which I won't go to in the interest of time, page 321 and 324 of the bundle, where we raised the point that we still make, which is that its costs were therefore in substance incurred in naira, and that the cost order should therefore be expressed in naira. Nigeria took issue with that as a matter of principle. They then, as now, took the position that they were billed in sterling and paid in sterling, and that in and of itself meant that costs should be ordered in sterling. We can then go back to the judgment of the Court of Appeal at paragraph 11, which quotes our skeleton argument for the consequentials hearing. There we submitted that Nigeria approves its budget and appropriates funds in naira. Its constitution provides that all monies shall be paid into a consolidated revenue fund, and we submitted it should be inferred that it was from that fund, a naira fund, that naira paid its costs, and that any costs would be converted into naira and paid back into that fund. And as the Court of Appeal noted, there was no dispute about any of that. Again, Nigeria treated the question as a pure question of principle. The argument before the judge then proceeded along those lines, and the judge then issued his ruling, which is at page 313. And paragraph 3, the judge says, although a large sum turns on that, the search, as ever, is for the correct approach. There's no dispute as to jurisdiction. The court has a discretion. The discretion is it to be exercised in accordance with both principle and the rules. Paragraph 4, I've had the advantage of argument from Mr. Milner, which presses for an approach that would treat costs in the same way as damages might be treated or an indemnity granted by a contract. And one view of Cathay Pacific, the learned deputy judge found a point of comparison between the cost jurisdiction and discretion and the approach whether an indemnity in a contract. I'm not able to accept that parallel is sound. And then in paragraph 5, in the present case, if costs had been incurred in naira, then this court, in the exercise of its discretion, might have found more that favoured the argument addressed by P&ID. But in the exercise of this court's discretion, the short and neatly expressed proposition from Mr. Ford for Nigeria prevails. This was a sterling liability paid by Nigeria in sterling, and it should be paid by P&ID in sterling. So the judge expressly declined to apply the principle that we were contending for. He did not actually identify any alternative principle expressly, but clearly he treated as decisive the fact that the costs had been invoiced and paid in sterling.
Might be thought he was applying the indemnity principle.
Well, I understand, with respect, why your Lordship says that. He obviously refers to the indemnity principle. What he is doing there is, in my submission, not quite making the argument that the Court of Appeal later made, which was squarely based on the indemnity principle. I think all the judge was saying there was that the fact that cost orders are subject to the indemnity principle does not of itself mean that the court should adopt the same current approach to currency as it would under a contractual indemnity. The indemnity principle, he's saying, in relation to costs, has a specific meaning, which is that you can't recover more than the liability.
Yes, he says it's a cap.
Is a gap, exactly. And that's obviously true so far as it goes, but it doesn't, in isolation, meet the argument that we were making. Our argument was not that costs should be treated in the same way as a contractual indemnity because costs are subject to the indemnity principle in the sense the judge explained it. The argument is much simpler than that. The argument is that costs should be treated as the same as a contractual indemnity or indeed an award of damages, because they have fundamentally the same purpose, which is to compensate the party for what it's spent or had to spend. Reverting to the facts then, it's common ground before the judge that Nigeria primarily transacts in naira, had regularly exchanged naira for sterling to pay its costs, and would convert any funds it received back into naira and paid into the consolidated revenue fund. We then had the hearing before the Court of Appeal some months later. Again, there was no dispute as to the facts. Nigeria did not seek to put in any evidence to explain how it paid its costs, and the Court of Appeal recorded in paragraph 11, as we've seen, what were the undisputed facts.
I suppose if we accept your argument today, the consequence in future would be that a party in Nigeria's position would have to put in evidence, and if it was a dispute, there would have to be a mini trial about it.
Potentially, yes. I mean, it's important to understand that, of course, that this is only likely to be a serious issue in cases where both the costs are large and the currency swing has been large. If that isn't the case, then realistically one wonders how many parties will seek to argue about it. But in any event,
I thought that would be quite a common occurrence in commercial.
Well, exactly. The rule exists in relation to damages, and in practice, as we know, it doesn't cause any difficulty.
But that's part of the trial. This would be satellite litigation.
Yes, and the courts, and I'll come to this, the courts do have the powers to, first of all, decide as a matter of discretion whether it's proportionate to have any inquiry into this at all. But if they do, what is the scope of the inquiry? What is the information that is needed? What disclosure should there be?
I mean, at some time, point my Lord Reid raised, I'd like you to pursue a little further as to how this would arise and how it would be dealt with. I mean, I think one would probably start with a party in the position of Nigeria saying, we incurred and paid our costs in sterling, that's what we want. And it would be for the opposing side to say, well, we think it's arguable that they suffered their loss in a different currency, and you would have to put in some evidence to make that, at any rate, runnable. The judge would then presumably have to give directions for Nigeria to put in rebuttal evidence. You might have an opportunity of putting in evidence the other way. That there might have to be oral evidence, I suppose. You might also seek disclosure of documents from Nigeria.
Yes.
So satellite litigation could well describe perfectly well the process.
It could, my lord, yes, but only if it is proportionate. And I mean, there are two ways it can arise, of course, and they're mirror images of each other. Either a party says, I'm claiming in currency X, and the other party says, I want to pay in currency Y, or vice versa. But yes, I mean, there might be a need for directions, some disclosure, some evidence. I'm not excluding that in an appropriate case, and Mr. Bacon will elaborate on this. But this is major litigation. This is worth tens of millions of pounds at this point. And so many long trials are fought over much less money than that. And so there are cases where it really is proportionate and appropriate to have that process. Just to develop that a stage further, the cost assessment in these proceedings, I don't know if it's been set down yet, but it's due to take place at some stage. It's going to take many...
Sorry, I mean, the notion of proportionality is in relation to the amount of costs, isn't it? The court will apply a proportionality test to the amount of the costs. But, I mean, it's a little bit different, isn't it? Can the court say, well, we're not going to inquire into this because we take the view it's not proportionate? I mean, how is it going to reach, I suppose, you'd say, well, the difference is only going to be X. So
yes,
that's the way it would work.
Yes, it is. And
yeah.
I mean, the court always needs to adopt proportionate.
So the court would have to say, well, because there's $1 million or pounds running on this, that's large enough to justify this process.
Yes, I can't give a one-size-fits-all answer, but the court will need to tailor its procedures and make a judgment as to what is appropriate.
Yeah.
Now, the Court of Appeal...
So we're back to the argument isn't worth the candle type situation. And so people are being excluded from raising an argument. You say, here's a perfectly legitimate point you wish to raise, and the court says, well, it isn't worth the candle. We're going to stop you from doing that. And that's a fairly draconian step for a court to take.
It might be, but it would depend on what was at stake and what it was going to consume in terms of court resources and costs to argue the point and so on. It does happen in relation to costs quite frequently. For example, the whole summary assessment process is in effect a broad brush approach where the court will not investigate in detail what was the purpose of each and every phone call and you know, there is a degree of granularity which about the exercise which varies according to the nature of the process and the circumstances of the dispute. And so it may well be that if there is only a relatively small sum that turns on a point and it's going to require a very extensive investigation, then the court will say it's not proportionate. Alternatively, the court may say this can be determined on the basis of a very limited amount of information which the receiving party should provide. I mean, there's any number of possible variations. Well, I've gone to the facts to make clear that the Court of Appeal dismissed the appeal on the basis of a reason of law, but it didn't therefore need to go on to consider what would be the position if it had to apply our principle to the facts. But if it had done that, it would have done so on the basis of the undisputed facts that I've set out and which it recorded in the judgment. Now, before this court, Nigeria has not sought to adduce any evidence. What it has done is simply assert in the statement of facts and issues and its written case that the explanation it provided at the outset in November 2023, and therefore the basis on which the issue was argued in both courts below, were wrong, and in fact the costs were paid in some different way. Mr. Hoskins will address this in more detail, but our position in short is that that is not a legitimate approach, and this court should not, with respect, entertain any attempt to depart from the undisputed facts that were the basis for the argument in both courts below. Now, I want to turn now to our case and the principle that we say should apply and why it should apply. The principle is, or is analogous to, the one laid down by the House of Lords in the case of the Folias. We've summarised the developments of the law in this area in our written case, paragraphs 16 to 35, starting at page 58, and none of that is in dispute. I just want to show the court how the principle was explained in the Folias and then what was said about it in relation to cost in Cathay Pacific. So the Folias is at page 1109. This case involved two appeals, one in contract and one in tort. In both cases, the claimants had to spend money, in one case to repair a vessel, in another case to settle a claim against it. And it had done so in a foreign currency, but it had done so by using its own normal currency of operations to acquire the foreign currency. And in both cases, the foreign currencies had depreciated in value, and in both cases, the House of Lords held that damages should be awarded in the currency of the claimant's normal operations, which had used to buy the foreign currencies. If we could turn to page 1121 of the bundle at letter F, Lord Wilberforce states the principle in the tort case as follows. In my opinion, this question can be solved by applying the normal principles which govern the assessment of damages in cases of tort. These are the principles of restitutio in integrum and that of the reasonable foreseeability of the damage sustained. It appears to me that a plaintiff who normally conducts his business through a particular currency and who, when other currencies are immediately involved, uses his own currency to obtain those currencies, can reasonably say that the loss he sustains is to be measured not by the immediate currencies in which the loss first emerges, but by the amount of his own currency, which, in the normal course of operations, he uses to obtain those currencies. This is the currency in which his loss is felt, and is the currency which is reasonably foreseeable he will have to spend. Now, I note here that if we are right that a similar approach applies to costs orders, then that passage applies squarely to our facts, such that any award would have to be made in naira. Mr. Hoskins will pick that up later. Lord Wilberforce then goes on to address some objections to this approach, which mirror some of the points made by Nigeria and indeed some of the points your lordships and ladyship have put to me this morning. The first of which is that it would involve complicated inquiries. As to that, he says, I'm not convinced of this. The plaintiff has to prove his loss. If he wishes to present his claim in his own currency, the burden is on him to show to the satisfaction of the tribunal his operations are conducted in that currency, and in fact it was his currency that was used in a normal manner to meet the expenditure. Now, I interpose that Lord Wilberforce is contemplating a claim by a claimant in his own currency. I will show the court in a moment that the principle actually operates neutrally, and those remarks are equally applicable where it's a defendant that says damages should be awarded in the claimant's currency, which is our situation. Later in the same paragraph, Lord Wilberforce addresses another point that's made by Nigeria in its written case. It said that this method produces inequality between plaintiffs. Two claimants who suffer a similar loss may come out with different sums according to the currency in which they trade. But if the losses of both plaintiffs are suffered at the same time, the amounts awarded to each of them should be equivalent, even if awarded in different currencies. If it happened that the currencies of the two plaintiffs relatively changed in value before the date of judgment, that would be a risk which each plaintiff would have to accept. Each would still receive for himself compensation for his loss. So that is linked to the point that my Lord Hodge put to me at the outset, that the currencies have changed value, and they're now, so that now 95 billion naira is the same as 25 billion naira. Not so with respect, because what one is looking at is only the amount of the currency, that's the relevant currency, that was spent. And if that's now not worth anything, that is irrelevant. Then it says, finally, it is said, and this argument would apply equally if the expenditure currency were taken, that uncertainty would take the place of certainty under the present rule. Undoubtedly, the present sterling breach date rule produces certainty, but it is often simpler to produce an unjust rule than a just one. The question is whether, in order to produce a just or juster rule, too high a price has to be paid in terms of certainty. I do not think so. Lord Wilberforce then considers the contract case, he explains that the starting point there is the terms of the contract, but he goes on to say at 1125, paragraph B, that if the contract doesn't provide an answer, then the damage should be calculated in the currency in which the loss was felt by the plaintiff, or which most truly expresses his loss. And again, that is not limited to the currency in which it first and immediately arose. And then he applies that to the facts, explains that there may be many variants of situations, but this is 1126. There may be many variants of situations in which a loss arises immediately in the form of expenditure or indebtedness in one currency.
Where are you reading from?
At page 1126, at letter H. And I underline the words expenditure or indebtedness for reasons that will become clear later on. It is money actually spent or money which is a party is liable to spend in one currency, but is ultimately felt in another, which other may be the normal trading currency of the plaintiff. And again, a statement that the currency in which the loss was borne or felt can be expressed as equivalent to finding which currency sum appropriately or justly reflects the recoverable loss. And that's a question of fact. So, my lords, my lady, there is a principle of law that damages should be awarded in the currency that appropriately or justly reflects the recoverable loss. The application of that rule is a question of fact in each case. Nonetheless, there is a body of case law that provides guidance as to what the result is likely to be in certain scenarios. Mr. Hoskins will refer to that in his submissions later. Now, my lord, my lady, I want to highlight two aspects of this principle which are important in the context of this appeal by reference to the textbook on foreign currency claims. This is a book called Howard, Knott and Kimball, which is at I don't know if your lordships have the additional authorities bundle.
Yes.
I'm grateful. It's tab 4 of that bundle, page 176. This is discussing the practicalities of the folias principle in the context of damages claims. And there are 2 points I want to highlight briefly. The first is its neutrality. There's no doubt that the principle operates neutrally as between claimants and defendants, so that a defendant is just as entitled to argue for a particular currency as much as a claimant is. There's no right of election, in other words. This is a point that's made at 14.5 and 14.6. We just read the beginning of 14.5. It is fundamental that the law is neutral as to the parties entitled to rely on the principles relating to foreign currencies. The changes in the rules were not intended to bring about an advantage to claimants or defendants, rather to correct imbalances brought about by currency fluctuations. And then if we skip to 14.6, it is therefore open to a defendant or third party to make a positive case that the currency or currencies in which any judgment is given should not be the one in which the claim is expressed. whether he asserts that sterling or some third currency is to be preferred. Where a defendant advances a case of this nature, the obligations discussed rest on him, mutatis mutandis. It follows that where the currency is raised by either the claimant or the defendant, the court has to resolve it by decision. It is not correct to talk of the court having a discretion, whether residual or otherwise, to allow the claimant to elect to have a judgment expressed in sterling or foreign currency. Now, I draw attention to that because Nigeria at times says that a paying party should not be allowed to compel or force the receiving party to accept payment in its own currency. In my submission, whatever principle applies, whether it's our principle or currency of liability or some other principle, it must logically apply neutrally. It can't be right that the receiving party has a choice of currencies while the paying party is stuck with whichever is most onerous. The second aspect I wanted to underline it concerns the scope of the inquiry, to come back to a point that your Lordships were asking me about a moment ago, the scope of the inquiry that needs to be undertaken to determine what is the appropriate currency in a particular case. This is discussed at 14.33 at page 188. The authors say that there's no authority on this point, but at 1435 they say in many cases there'll be no difficulty. At 1436, more difficulty arises where the claim is for damages in a currency with which the claimant, rather than the claim, is particularly concerned, and that is analogous to our case. Now, having said that, of course, in this particular case, there's no difficulty because Nigeria has told us it transacts primarily in naira and it paid its costs by converting naira to sterling, and that's no further inquiry is necessary. But even in a case where the position was less clear, as I said earlier, it would be wrong to assume that the inquiry would necessarily be extensive, let alone disproportionate. Mr. Bacon will say more about this with reference to the nature of detailed assessment proceedings, but I just want to show the Court paragraphs 14, 41 and 42. Paragraph 1441 says that a full disclosure exercise would be capable of being grossly disproportionate. But then 1442 says this does not seem to have presented problems in practice, probably due to the fact that it's the context of commercial litigation this kind of dispute most commonly arises and has sufficient significance for it to be pursued.
Sorry, I'm just lost you. Where are you?
Sorry, my Lord, 14.42.
Thank you. Right.
For the same reason, there's a high premium on practical dispute resolution. The parties and the lawyers usually have a common interest in bringing forward disputes in an orderly way and have the experience to know what are the requirements of conducting litigation in a pragmatic fashion. And then this, if it is thought that if a dispute were to arise, the court would take the view that disclosure ought to be as circumscribed as possible. And they suggest proportionate ways of doing that. And then towards the end of the paragraph, there's a sentence that says the court is perfectly well equipped to exercise a broad discretion in such cases and to decide whether to require pleading, statements, lists of documents or disclosure of documents. Now, I take the point that this is in the context where there is already a substantive set of proceedings ongoing, but it is nonetheless contemplating pleading, statements, lists of documents and disclosure of documents specifically directed to this currency.
All as part of a trial process?
As part of a trial process, yes, but they're nonetheless over and above what would otherwise be required in the trial to deal with the currency point. So, of course...
Do any of the various paragraphs you've taken us to refer to cost disputes?
No, my Lord. This book was published in, I think, 2016, and the issue just hadn't been considered in any detail. But one of the authors of the book then became the deputy judge in the Cathay Pacific case, which I'm going to go to next. So this is not contemplating specifically cost proceedings, but my point is that similar principles can and should apply in relation to costs, of course, taking into account that it is, in a sense, satellite litigation and that there's an emphasis on proportionality, but nonetheless, the tools are there to achieve that. Now, against that background, can I next invite the Court to look at Cathay Pacific, which is page 553. This is in this case, it is a costs case, and the receiving party was a German company that had been invoiced for and paid its costs in euros. A lot of the judgment is concerned with whether the court had jurisdiction to order costs in a foreign currency. The judge held that it did, and that's common ground. It's in that context that at paragraph 43 on page 562, the judge makes the observation that, quote, an order for the payment of costs is a judgment like any other, and that the ordinary rules therefore apply. My learned friends criticise that starting point, but it is right insofar as a costs order is a judgment, and judgments can be entered in any currency as a result of the Miliangos and the subsequent case law. The judge then goes on at 45 to say it's routine for the courts to give judgments in foreign currency and have done in a wide variety of cases, including damages and indemnity claims. And then he says this: to the extent that an overarching principle has emerged, it is that a court ought to give judgment in the currency which most truly expresses the claimant's loss. He then goes on under the heading the indemnity principle to say that costs are awards of a statutory indemnity. I will come to the indemnity principle shortly and explain the two different senses in which that term is used. What the judge means by it here is that cost orders are by nature intended to be compensatory. That is the point of the quote from Harold and Smith, with its reference to costs corresponding to the extent of the damage.
Just looking at this, the overarching principle, the overarching importance of Miliangos was that it established that the English courts could give a judgment in a foreign currency. I think Miliangos was a debt claim, wasn't it?
Correct.
So until Miliangos and the Havana and regular warehouses case had established this, the English court had no jurisdiction to give a judgment in any currency other than sterling. And that was the critical importance of Miliangos. So that's one thing. He's then segued into something different, namely, how do you approach the question of which currency to use when you're seeking to provide damages for loss? So he's moved from the basic principle established by Miliangos to a subset. He's not there concerned, obviously, with debt claims, for example.
Correct, Michael. And the link is the Folias case, which we've looked at. So Miliangos says you can give judgment on a debt claim in a foreign currency. The Folias, which we've just seen, extends that to damages claims.
Yes.
And there are other cases, and we set out the whole history. There's a case called the Dione, which extends it to contractual indemnities. And in this case, it's applied to costs as well. And I should say, there are other types of orders. I mean, it applies to unjust enrichment, for example, where the question is, what is the value of the benefit? Again, the same principle by analogy applies. In what currency was it in substance received, rather than in what currency was it immediately expressed?
But the question in this case is whether the sentence, to the extent that an overarching principle has emerged, has any applicability to an award of costs.
Yes.
That's the real
exactly, and it is. And certainly that is the principle that applies to damages and indemnity claims. And the reasoning that he then goes on to develop is that costs are an award of a statutory indemnity, and we'll come back to exactly what's meant by that, perhaps, but they are compensatory fundamentally. They have the same essentially compensatory function, and therefore it is rational to apply the same basic approach. The quote in 47 from Lord Justice Longmore is intended to make the same point, that costs are compensatory. Now, the Court of Appeal seized on that and said that they compensate for a liability and not a loss. Now, I'm going to come to that point. But at this stage, the judge is simply making the basic point that costs orders are compensatory. So, as I say, it is rational in principle to apply the same compensatory principle articulated in the Folias. And that is what the judge says in terms at 48. He says, given that a costs award is intended to be compensatory and in the form of a statutory indemnity, there ought to be no difficulty in principle in applying the Folias in this context. The question is, in which currency is it most appropriate to compensate the receiving party for its expenditure on the litigation? Then he points out that that approach has already been adopted in relation to a contractual indemnity in the Dione. In 50, he says, in my judgment, there is no reason why the same approach as was taken in the Dione should not be taken in the context of a statutory indemnity for the award of costs. The fact that the source of the right to the indemnity in one case is a contract and the other statute makes no difference. In both cases, it is appropriate to inquire as to the currency which most truly reflects the loss which the claimant has suffered. And then he says the application of that to the facts is straightforward. Now, my learned friend suggests that all of that discussion is obiter. It doesn't actually matter before this court whether it's obiter or not, because, of course, your ladyship and your lordships are equally free to agree or disagree with it. And indeed, it wouldn't matter if it had never been said at all. I'd still be entitled to make the same submission. But for what it's worth, in my submission, it's rather unreal to suggest that's not part of the ratio of the decision. The judge expressly arrived at his decision by applying the folias principle to the facts. The fact that he could have reached the same result by a different route, such as, for example, taking the currency of the liability, is, with respect, neither here nor there.
He seems to have taken that route also in paragraph 28, doesn't he? Page 559. 28A and 28B. Directly in the currency in which the costs were, in fact, incurred.
Yes, well, I mean, that is true, and on the facts of that case, those were the facts. But obviously, the whole point of the folias, as we've seen, is that the currency in which the loss is, in fact, incurred may well not be the currency in which it was immediately paid.
I don't know why he went into all this, really, given what my lord has just said. It seems to have been a bit of a sort of excursion
yes,
of interest to him in the light of his writing. But what was the relevance of it to the issue in the case? Given, I mean, if one applies milliangos to an award of costs, I mean, that's a point he could address there. He's come to an answer, and that's that, isn't it?
I think the Chancellor in the Court of Appeal made the observation that it was a case of using a sledgehammer to crack a nut, and with respect, I wouldn't necessarily disagree with that. He could have reached the same result by applying different
So these are obiter observations.
Well, in my experience, they're not obiter observations because that is the way that he arrived at his decision. He applied the principle to the fact, and doing so, it was straightforward because absolutely everything pointed towards euros. The costs were billed and paid in euros, but also it was a German company spending its normal currency. And so there was really no complexity about it at all. But if that is the principle, and I submit that his reasoning, his essential reasoning is right, that there is no reason not to apply that in relation to costs, given that they are functioning as an indemnity and as have a compensatory purpose, then one does apply the folias, and that points you, in a case where the currency of expenditure and the currency of in which the expenditure was felt are different, that points you clearly to the currency in which the expenditure was truly felt. Now, I wanted to refer briefly to just one more case which we submit provides some support for our approach, and that's the case of Elcomet, which is at page 558.
Could I have the page number, sorry?
588, I misspoke.
Yes.
588. In this case, the receiving party, Elcomet, was a German company and had to exchange euros for sterling to pay its bills, just as Nigeria exchanged naira in this case. But unlike naira in this case, the euro had appreciated against sterling over the course of the litigation, and so Elcomet sought an order compensating it for the currency losses it would suffer if it received payment in sterling. Mr. Justice Arnold, as he then was, said at page 590, paragraph 8, that the difficulty could possibly be avoided, at least to some extent, by an order for costs expressed in euros. However, despite the fact that Saint-Gobain is a French company, Saint-Gobain has declined the invitation to accept payment in euros.
Sorry, which paragraph again?
It's paragraph 8, I think.
8.
So the judge decided to award an additional lump sum to compensate Elcomet for the currency losses. Now, it's not clear that he had jurisdiction to do that, but that's so be it. But the point I want to emphasise is that the judge recognised that the simplest and most attractive solution would have been to order payment in euros, not the currency of the liability, but the currency that the receiving party had to spend to acquire the sterling to pay its bills. And it shouldn't have made any difference that the paying party was unwilling to accept payments in euros. The paying party should no more have a right of election than the receiving party should. So drawing some threads together at this point, my lady, my lords, we submit in agreement with the judge in Cathay Pacific as follows. There's a clear and well-established principle that applies to determining the currency of orders for the payment of money generally. That principle applies in particular, but not only, to awards aimed at compensating a party for loss or expenditure. Cost orders are, of course, orders to pay money. Cost orders are also compensatory. Their purpose is to compensate the receiving party for what it has reasonably spent or will reasonably have to spend on the litigation, or is liable to spend on the litigation. I have no problem with that formulation. That has been the case for a very long time. As we set out in our written case, paragraphs 38 to 47, we trace the history and nature of cost orders from their very earliest days. We had happy days in Lincoln's Inn Library researching some of those very early cases.
Sorry, maybe you made this point, but I was just puzzled at the end of paragraph 7, Mr. Justice Arnold refers to Elkamat as the paying party. It was the receiving party, wasn't it?
I think that's a mistake. Yes,
yes, all right.
It has to be the receiving party.
Thank you. Sorry, you were taking us to Lincoln's Inn Library.
Well, I'm not going to go there, just to say that we traced the history of cost orders from the earliest days. And it's very clear that they have had a compensatory function for a long time, and that remains the case today, notwithstanding various legislative developments, which means that the costs are no longer available as of right. And in our submission, it is logical and right in principle to apply the same approach to selecting the currency of a cost order as another kind of compensatory order, such as an order for damages. Now, Nigeria put forward essentially two reasons for saying a different approach should be adopted for cost orders. Those are set out in section C of their written case, which is headed "Costs are not damages." The 2 points essentially are, first, that costs are not the same as damages, juridically, as it were, and secondly, that the indemnity principle either does not require or positively prevents the application of our principle to cost orders. Dealing with the first point, that costs are different from damages, of course it's true, even a truism, that costs and damages are not governed by the same rules. For example, damages are available at common law, whereas cost orders are statutory. Damages are available as of right, whereas costs are ultimately discretionary. There are also differences, though sometimes quite subtle differences, in terms of the principles by which damages and costs are assessed. Now, all of those can be said to be differences between damages and costs, but one has to ask what relevance they have to the question we are concerned with in this case. In our submission, they don't have any relevance at all. At most, the fact that there are differences between costs and damages shows that there could, in theory, be a different rule as regards currency. But they don't in any way show that there is or must be a different rule, let alone what that different rule should be. So that argument in itself doesn't, we suggest, go anywhere. Before moving on, though, I should address one particular aspect of the cost jurisdiction which Nigeria does suggest is relevant, and that is the fact that an award of costs does not extend to incidental or consequential losses such as funding costs. Nigeria even goes so far as to say in its written case, paragraph 27, that the fact that funding costs cannot be recovered under a cost order is a complete answer to this appeal, page 107. Now, with respect, that is not right. The error is to treat an award of costs in a particular currency as if it involved awarding a separate and additional sum over and above the costs themselves to compensate for a currency loss. But with respect, it doesn't. And the reason funding costs are not recoverable as costs is simply that they're not within the meaning of the term costs in the Supreme Court Act. I wasn't going to go to it, but that is made expressly clear in a judgment of the Court of Appeal in a case called Rowe and Ingenious, which is in the Supplemental Authorities at tab 3, paragraph 49.
What page number in the sub?
It's tab 3, page 49.
Yes, not to worry.
Supplemental Authorities, I'll be given a page reference. Lord Justice Popplewell makes the point in terms that funding costs are not within the definition of costs in the statute. It may be that awards of compensation for currency losses are also not within that definition, in which case Elcomet was wrong in that respect to make such an award. So be it. But when the court orders a party to pay costs in a particular currency, it is only awarding the costs themselves, nothing else. Not awarding the costs plus an additional sum for currency losses, any more than it's making a deduction from the costs in a case where the currency is depreciated. It is awarding the costs, and only the costs, but in the currency it considers appropriate. And the same applies, I'm told it's page 165 of the Supplemental Authorities Manual.
Thank you very much indeed.
The same applies to awarding damages, for that matter, in a foreign currency. When the court awards damages in a foreign currency, it's not awarding additional damages to reflect currency fluctuations. In fact, it's a controversial question whether the court can even do that. But there's no controversy at all about the fact that it can award damages in the currency that best reflects the loss. So neither the fact that costs are not damages nor the fact that funding costs are not recoverable under a costs order provides any reason not to apply the general principle that compensation should be awarded in the currency in which the costs were truly felt or borne. Turning then to the second argument, based on the indemnity principle, I need first of all to clear up the distinction between two senses in which the phrase indemnity principle is used in the authority. The first sense in which the term is used is to refer to a general common law principle of compensation. In that sense, it is the principle that compensation should correspond to the loss that it's compensating. It should be adequate, but not excessive. And we've cited two cases in our written case, footnote 35, page 78, where the indemnity principle in that sense has been said to, quote, lie at the heart of the common law approach to damages, in the words of Lord Justice Morbick. But the same principle also applies to costs, and that is the principle that was articulated in the well-known case of Harold and Smith, cited at paragraph 43 of our written case. Baron Bramwell famously said that costs as between party and party are given by the law as an indemnity. They're not imposed as a punishment on the party who pays them, nor given as a bonus. Therefore, if the extent of the damnification can be found out, the extent to which costs ought to be allowed is also ascertained. Now, the court there was not commenting on how you measure the damnification. It wasn't saying anything about the difference between liability and actual expenditure. All it was saying was that a cost order should compensate for the loss or damnification suffered as a result of the relevant event. In that case, it was some amendments to a pleading. And all the court was saying was that the compensation should correspond to the costs that were incurred as a result of that event. That is also the sense in which the Deputy Judge used the phrase indemnity principle in Cathay Pacific. He uses it in the heading above paragraph 46 on page 563. He was saying that because costs are compensatory, it is more consistent with that position to compensate the receiving party in the currency that truly reflects its loss. Now, when the indemnity principle is understood in that sense, our case is consistent with it, whereas any other approach is inconsistent with it. Our case is consistent with the indemnity principle in that broad compensatory sense, because that is the only way to ensure that the receiving party is adequately but not excessively compensated. By contrast, to allow a party to make a profit in the way that Nigeria stands to do in this case, by reference to the currency in which it was actually operating, is contrary to the indemnity principle in that sense.
Can I ask you this? If Nigeria had kept its reserves in gold rather than naira, and the price of gold had declined substantially over the period with which we're concerned, would the same principle apply? Would you award a much lower figure by way of costs because of the nature of Nigeria's loss?
Well, obviously gold is not a currency, so
it's a store of value.
Yes. So ultimately one is looking for the currency in which...
So this is a rule which is confined to currency losses and gains, not others.
Certainly it's a rule that is confined, it applies to currency. It's not, I would say, a rule about losses and gains. It's a rule that simply asks, in what currency was the loss experienced?
Because the principles that are referred to in the tort and contract cases you've referred us to are talking about loss generally. They're not talking just about currency losses. They're applying general principles of loss to currencies. But as I understand it, you're saying that in the world of costs, it's a rather special rule that confines the question of loss to the question of which currency you award the costs in.
I don't accept, with respect, there's any distinction to be drawn. The damages cases, of course, talk about loss because that's the question in the damages case, how you measure the loss. And the question then is, in what currency was it truly experienced? And
in my example, if it was a tort claim, would Nigeria, if it had been forced to sell gold, not be able to recover the cost at which it had sold, rather than being restricted to the value of the gold at the date of trial?
The court would have to identify the currency in which the loss is most appropriately measured. And there is an interesting parallel. It's an unjust enrichment case, in fact, of BP and Hunt in the judgment of Lord Gough. And there, the benefit that was received was oil. And the court had to decide in what currency should this benefit be measured. And that's essentially, it's a very similar question to the one your lordship is asking. And the court determined, I can't remember the detail of the facts, but that part of the loss was measured in US dollars, and I think part of it was measured in sterling. But if the loss... I mean, ultimately, the court is awarding money. That's all the court can award.
So, I mean, on the facts of this case, just to be clear about it, if Nigeria had kept its reserves in gold, you would not be arguing that the amount of costs it should be awarded should reflect the value of gold at the date of the costs order.
No, I wouldn't be arguing that. I might still be arguing for naira, depending on...
No, they had nothing to do with naira. They didn't keep any of their reserves in naira, in my example.
I see. If it's simply selling gold for sterling,
yes.
Well, potentially.
So they would get the costs, the sterling costs that they had incurred, rather than the value of the gold at the date of the costs order.
Yes, I mean it's an impossible question to answer in the abstract because it would depend on the facts and
well, I've given you that.
Yes, but I mean, on facts such as how the gold trading operates. And
they went on the spot market and they sold their gold at the time they needed to pay their costs. Otherwise, the evidence establishes they would have kept the gold, and it would, by the date of the costs order, have been worth a great deal less than it was at the date when they sold it in order to pay their costs.
Yes. I mean, the burden is on us to show that the loss was suffered in naira, or the expense of the litigation was truly felt or borne in naira. That's our burden. And the more...
The answer to my question is it that they would have recovered their £44 million of costs, in my example? I mean, subject, obviously, to assessment.
I'm not trying to evade the question, but I find it difficult to give a yes-no answer, because it would be a question of fact for the court to identify the currency in which the loss was
well, let's assume that Nigeria the government never kept its reserves.
Yes, if there's no connection to naira, then of course...
It kept its reserves, as I say, in gold, or it could be US dollars. As a major oil exporter, it might well be expected to maintain very large US dollar reserves. But anyway, those are my hypotheticals.
Yes, my Lord, that's right. I mean, it may well be the case that we would not be able to show that the loss was suffered in naira on those facts. And similarly, I mean, Lord Wilberforce in the Folias gave the example of an international company that regularly transacts in multiple currencies. There, too, it might be difficult to show that the loss was suffered in one currency rather than another. But those are obviously not our facts.
What happens if it's a domestic case and the loss is felt by a litigant having to sell a painting and the painting devalues? So he sells a painting in order to fund his litigation costs.
Well, there's no currency issue in that example.
So it's purely confined to currencies then?
Yes, so all of the submissions are entirely directed at what principle should the court apply when it is asked to decide between two currencies. That is the only issue.
But why, if the principle is a broader principle that you should recover your costs in the amount that they are felt? Why is it limited to currency? Why doesn't it extend to the borrowing or the opportunity costs as a matter of principle?
Because first of all, that isn't the principle. I'm not submitting that there's a broad principle that loss should be compensated. My principle is that it's only a principle that relates to currencies, and the principle is that when the court is deciding between different currencies, then it should identify the currency in which the loss or expenditure that it is compensating was truly felt. That is the extent of the principle. And there's no relevant difference between the position where the court's awarding damages and the position where it's awarding costs.
But in a damages situation, the court will look into the points that my lords have raised with you. If the loss was felt in gold rather than in sterling, the courts will look into that in a damages situation. They don't limit it to currency. It may be that in those particular cases, currency was the issue. But you're saying there's an artificial limitation in a costs situation by reference to currency.
I don't think this, but I'm saying there's an artificial limitation. There are rules that govern the assessment of costs, and those rules determine what costs, what items of costs are recoverable. The only question that one needs to identify a principle for is how you determine in what currency they should be expressed. And my submission is that should be the same principle that is adopted to determining the currency, and only the currency, of other types of compensatory award. And there's no logical reason to do differently.
So just take me to just explain the assessment process then. So if it's not a summary assessment, the assessment is conducted in sterling. So that somebody comes along and says, well, I have an hourly rate, the hourly rate is X, look at the importance of the case and my seniority, etc. And that's a justifiable hourly rate. Would that be correct?
My Lord, Mr. Bacon is going to deal with this because he has very much more experience of it. Yeah. But yes, I mean, that is, in a sense, it can be put like that. Can I just...
I thought if I had understood properly that we weren't really talking about assessment, but rather a mini trial in order to decide on the order for costs that the judge should make. And the question of a detailed assessment by a cost judge would be subsequent to that.
My Lord, there are two ways it could work. A judge would be perfectly entitled to say that the question of currency should be determined by the cost judge on detailed assessment. That would not be a particularly exotic thing for a cost judge to have to do. But in some cases, the judge could equally give a direction, if the judge was in a position to do so, to say that the costs should be assessed in a particular currency, and that's what we invited the judge to do.
Do you mean that? Assessed in a different currency? Or do you mean paid?
I thought you were going to convert it. Is that the date of payment?
Yeah.
I mean,
was going to be
how you
assessed.
could really conduct an assessment in euros when you're trying to compare senior and junior partner rate with sterling rates in London.
No, absolutely. But I mean calculated and
You did mean
yeah,
that.
I mean
not
calculated and paid.
It would be assessed in sterling.
Yes, I mean in a sense it doesn't matter ultimately in what currency one conducts the assessment, but clearly it's much more convenient to do it in sterling because that's A, what they've been billed in, and B, what everyone is familiar with. So.
But you're envisaging the judge, I mean, unless I've not followed properly, I thought you were envisaging that the judge would be invited to make an order essentially modelled on Milli-Angos, but applicable to costs rather than damages. And he would have to hear such evidence as he required in order to decide whether such an order was appropriate.
That could be done by the judge, absolutely, but it could also be done in the context of a detailed assessment proceedings, and Mr. Bacon will explain that. But it certainly wouldn't be a problematic thing for a detailed assessment to incorporate in an appropriate case. But in what's left of my time, I think I need to come on to address the Court of Appeal's key point about indemnities. And perhaps I was explaining the two senses of the indemnity principle, and I explained that it is in part a broad compensatory principle, but it also has a specific meaning in relation to costs, which is the rule that a party cannot recover more than its liability. Understood in that sense, the indemnity principle doesn't actually advance anyone's case. It is essentially irrelevant. We don't say that for Nigeria to recover in sterling would breach the indemnity principle in that sense. We accept that the ceiling is set at the liability, which is 44 million sterling. But, and this is the crucial point, the reverse is also true. So the indemnity principle does not prevent the court from considering what is the appropriate currency in which to award costs or awarding costs in that currency. So if this is otherwise the correct approach, the indemnity principle does not stand in the way of it. And this is, with respect, in our submission, the flaw in the reasoning of the Court of Appeal. The Court of Appeal assumed that because the indemnity principle capped recovery at the level of the liability, that means that costs must be awarded in the currency of the liability. But it did not really explain why that followed, and on proper analysis, in our submission, it does not follow. And can I just invite the Court to take up the Court of Appeal's judgment, page 166. At 58, after summarising the decision in Cathay Pacific, Lord Justice Snowden said, I agree with John Kimball that an award of costs is a form of statutory indemnity. However, it's not an indemnity against loss, it's an indemnity against the liability to the lawyers. And he goes on to refer to a series of cases where paying parties have argued there will be a breach of the indemnity principle because the receiving party will not have to pay its own costs. In all those cases, the courts have held there's no breach of the indemnity principle because there's still a liability, and the indemnity principle is only concerned with liabilities. But the critical point is that the fact that a cost order compensates for a liability does not mean that the court can't inquire into the currency in which the liability should be compensated. That just doesn't follow. The key point is that the court is making an order to compensate someone. It may be awarding compensation for a liability, but it's still compensation, and it is therefore not just possible, but necessary to consider in what currency the order should best be expressed. The position is no different in principle from where a party is claiming damages in respect of a liability. If the liability is incurred in currency X, but is discharged using currency Y, then either party is entitled to argue that the liability should be compensated in currency Y rather than currency X. And indeed, Lord Wilberforce expressly referred in the folias, as I mentioned, to expenditure or indebtedness which is incurred in a particular currency but felt in another. There's no rule in the damages context, as I say, according to which a liability has to be compensated in the currency in which it immediately arises, and therefore no reason to apply such a rule to cost orders. So we therefore respectfully submit that the approach of the Court of Appeal was erroneous in that way and should be rejected. Contrary to the view taken by the Court of Appeal, where the court is awarding what is compensation for a liability, it is both possible and appropriate to award compensation in the currency which most fairly compensates the receiving party for the cost of discharging that liability. And I need to conclude, my lady and my lords, but I just want to make one final point, which is that there is a tension in Nigeria's case between arguing for two principles that actually pull in different directions. The logic of the Court of Appeal's decision is that costs should be awarded in the currency of the liability. But parts of Nigeria's submissions, if they were right, would point towards an order in sterling, even if the currency of the liability was different. For example, paragraph 80 of the written case, they say, this is page 131 of the bundle, over to 132. They say it's the practice of the cost judges to assess an order cost to be paid in sterling, even where a party is paid cost in a foreign currency, calculated at the date when the costs were paid to the lawyers. So they say that even if Nigeria had incurred a liability in naira, it would still be entitled to recover in sterling. Now that's supposedly based on decisions in the cases of Deutsche Bank and Mikula. There is a disagreement between us as to whether those cases actually do stand for that principle, but the point is that those courts did, it's true, award cost in sterling as if the liability had been in sterling, even though in fact the liability was in a different currency. So those are inconsistent with the idea that you have to award costs in the currency of the liability.
Well, was there argument about that in those cases?
There was no
issue between.
There was no argument about whether our principle applied as such, but there was argument about
which currency,
and about when the conversion should be done and whether it should be done at the date of the cost being paid, so as effectively to crystallise a sterling amount then, as if it had been a sterling liability from the outset, or whether it should be converted at the date of the assessment or the date of payment, so as to make it essentially a foreign currency liability.
It was as at the date of the payment?
It was, yes, so it was treated as if it was a sterling.
No argument that even though the liability had been incurred and paid in euros, the cost should be awarded.
I mean, not as such, not as such.
So yes, this point.
Now,
can I just, there was one point, before you sit down, one point I did just want to put to you. It might be said against you that if one looks at the statutory provisions, section 51, and then the CPR, that there's nothing to support your compensation approach.
Well, the statute merely says that the court has a discretion as to the costs of an incidental to the litigation. Now, that, it's agreed, means that the costs can be awarded in any currency. So the question is, what principle, and this is why we're here, what principle does the court apply when two people are arguing for different
costs are incurred in a foreign currency, then there's no difficulty in saying those are the costs.
So that points to the liability as being the only currency that the court can award costs to. It does. In my submission, the statute does not need to be read in that narrow way. The court has a discretion as to the costs, and that includes in what currency the costs should most fairly and appropriately be expressed. It's much more flexible than that, in my submission. And that brings me to the final point, which is that, as I say, the court does need to decide with respect what is the principle, if not our principle? Is it the currency of the liability? Is it sterling, or is it something else? And we do submit that our principle is the most appropriate, because neither of the alternatives solve most of the problems that Nigeria says would arise on our approach. If one takes currency risk, for example, and who should bear currency risk, our principle goes further than the others to eliminate currency risk. For the receiving party, there is no currency risk because it receives compensation in the currency in which it truly experienced the loss. I think that's common ground. The objection is that the risk is on the paying party. But from the paying party perspective, there is no reason to think the risk is any greater where the cost order is going to be made in the receiving party's currency, as opposed to the currency of the liability or sterling, as the case may be. For the paying party, there's currency risk in every case where it operates in a different currency from the one which the cost order is eventually made in. So on our approach, only one at most of the parties bears any risk. And it is right that it should be the paying party we submit, because after all, if the relevant currency is depreciated, there'll be no cause to complain. If the currency has appreciated, well, the receiving party, as the successful party, should be adequately compensated for its costs. And to adapt what Lord Wilberforce said in the Foliat, the paying party must take the receiving party.
Well, I don't understand that. I mean, if naira had gone up greatly in value, and from the date the payments were made, how would payment in naira be compensation? That would be potentially a windfall, wouldn't it?
With respect, my Lord, no. I mean, if the facts were reversed, if let's say that they spent naira equivalent to, they spent 25 billion naira, they're getting 25 billion back. Now, it may be that 25 billion today is, in sterling terms, is worth more than it was. But the whole point of this exercise is to identify the currency that expresses what they have spent and the currency.
When you said it was expressing their loss, not what they'd spent. We know what they spent.
Yes, well, I mean the currency in which the expenditure was truly felt, and that is the essence of the principle. So, and as I say, that's not the currency that it was immediately spent in. It's the currency that, in substance, they felt it in, which is their normal currency of operations, which they used to acquire the sterling. If they spent 25 billion, they got 25 billion back. They have been made whole, and whether that's appreciated or depreciated as against sterling is entirely irrelevant. So there are problems with both the alternative approaches, and we submit both of them would be a rather arbitrary straitjacket to put the court in, to require it to award costs either always in sterling or always in the currency of a liability. And that our principle is the only, ultimately, but the only fair and appropriate one to adopt consistently in each case. It gives the court the flexibility to award costs in the appropriate currency, applying a test that is well recognised and understood, and we therefore invite the court to endorse that principle. Unless the court has any more questions for me, I will hand over to Mr. Bacon.
Thank you very much, Mr. Milner. Yes, Mr. Bacon.
Yes, my lord, my lady. May it please you, I was asked to address really three matters. The original timetable meant that I should have finished by now, and so I will be as brief as possible. Mr. Hoskin, I think, has more to say, and that's not a criticism at all. It's the way that things are. What I was planning to do was to address some of the concerns ad hoc, as it were, rather than stick to the script that I had prepared from my lords and my lady as to the approach to be taken. There are 3 points. There's practicality, proportionality, and some policy points. So far as practicality is concerned, the Court of Appeal did express concern about that at paragraph 64 of its judgment below. That's at page 168 of the bundle. It specifically, my lords and my lady, the court thought it important to observe that first instance courts grappling with these issues and or cost courts would usually have, quote, no idea of the arrangements which the receiving party has used to obtain the funds to pay its lawyers, and it would, quote, often be entirely inappropriate and disproportionate for the court to embark upon such an inquiry. Now, we say, with the greatest respect to the Court of Appeal, these two observations are inaccurate and obviously overstated. Addressing the first, it's actually not uncommon in the modern day for the courts and the receiving parties, the assessing court, the managing judge and the underlying claim, to have some visibility as to the arrangements which underpin the funding of the claim. Funding arrangements in large cases often involve third-party litigation funding arrangements. It is not uncommon for inquiries to be made about the nature of those funding arrangements. The terms upon which lawyers are instructed is often the subject of discussion at summary assessment hearings, budgeting hearings. And of course, it goes without saying that if a court wishes to know more about the nature of the funding arrangements which underpin the claim, then the court can, of course, inquire about that.
Well, could it really? I mean, if you've got a budgeting hearing or something, so you're saying how much is going to be spent at each stage and so on, and the solicitors are billing and being paid in sterling,
yes,
would it really be open to the court to inquire how the party is going to raise the sterling needed to pay its solicitors? That seems to be well outside what is relevant to a sort of budgeting hearing of
totally accept it wouldn't be on the agenda.
Yeah.
But if the paying party or either party had a concern that was relevant in the final analysis to the subsequent costs order, it could raise the issue with the court. And the court at that stage is likely to say, well, noted, but potentially a matter for another occasion. Or it could, if it wished to, not so much on a budgeting hearing, interrogate the matter further. There are nuances to the nature of the terms of indemnity which become relevant. Are the costs being funded by a litigation funder? These sorts of matters are often the subject of inquiry. So far as budgeting is concerned, my Lord, just to answer the relevance of that, I mean, a point is taken against us that the civil procedure rules, fixed costs, budgeting and cost capping, this is the policy argument in the third list of my points, rather speak against the proposition which we advance on this side. But with respect, they don't. The budgeting exercise could conceivably be an exercise which is obviously expressed in sterling in the usual way, but the judge, if the judge was satisfied there was a genuine issue as to the appropriate cost order to make in the final analysis at the end, it could make an observation making that clear that that's a matter for potentially for subsequent debate. I'm not suggesting that budgeting hearings should take place in foreign currencies. I hope that's clear.
But fixed costs are in sterling.
Fixed costs are in sterling, and I accept.
They always have to be paid in sterling.
They do.
And the liability is always in sterling.
Indeed.
Yeah.
Don't push against that at all, my Lord.
Yeah.
So far as
it matters not
no,
a jot or a whittle.
It doesn't.
As to whether they were paid in any foreign currency at all.
They're fixed costs. They don't represent any meaning in any meaningful sense, equating to the actual legal spend. They've got nothing to do with what has been spent. You can recover fixed costs if you spent a penny. So we essentially say that it's an inquiry which is by no means off limits. This inquiry about the nature of the real loss that was suffered by a receiving party, and typically at the end of the case, which is what we're really concerned with, I'm sure we're all agreed, the court can and does have the jurisdiction to inquire into the nature of the funding arrangements. I mean, I give an example, a perhaps more obvious one, is where a party seeks what is now quite common, fairly convoluted interest claims, where one seeks an order for interest to be dating back to the date on which the costs were actually incurred. It's a relatively modern phenomenon, but now quite common. In order to exercise the jurisdiction toward interest, in fact, it happened in this case. The judge has made an order that backs date interest. You need to know when costs were paid, and so very often the invoices are identified, the invoice dates. when payments in respect of the invoices were actually made so that interest can run from the correct date. And of course, by having visibility of those facts, one sees the currency in which the expenditure was made. And if there was a genuine issue about whether or not that currency is the correct currency for the court to finally order costs to be paid, the court can investigate that genuine issue. So far as genuine issue is concerned, I raise that because it was a point raised by my lords early on about whether or not this is likely to cause satellite litigation. My lady referred to that, indeed my Lord Hodge referred to it, and about satellite litigation, which is obviously undesirable in cost assessments from a sort of starting point. But one has to be careful about the description of satellite litigation in cost assessments when one is particularly talking about such substantial sums and its relevance to the interests of justice and fairness. I mean, it's not uncommon for there to be so-called satellite heavy disputes in cost assessments. My learned friend, Mr. Carpenter, will doubtless agree that where there are genuine issues over the terms of the retainer, genuine issues can result in mini trials, cross-examination of witnesses and solicitors, and conduct issues arise in assessment cases where, again, mini trials can take place where cost judges are determining factual matters to determine genuine issues over the reasonableness or otherwise of the costs that have been incurred. So with respect, I totally accept the concern, but it's not a concern which should outweigh the jurisdiction, which is really what is being advanced against us. My Lord, in answer to my Lord Stephen's point about whether or not a judge can really say, no, it's too disproportionate for you to be permitted to pursue the point, with respect, I think the court, I would submit the court can and does have that jurisdiction, and we see it properly exercised in indemnity principle cases. Whilst I was sitting here, I was trying to find the best example of that in operation, and fortunately, if one turns to page 549, again, this is off script, but helping to be of assistance as much as I can to the court. At page 549 is an extract from the Burstein case, which is an indemnity principle case. At paragraph 24, this was a case about whether there should be an inquiry into the nature of the terms upon which the solicitor was instructed, and whether or not there'd been a promise that there wouldn't be any liability to pay if there wasn't any damages recovered. And in a part of the approach that the court took, as expressed at paragraph 25, there was a reference to Miller and Glennie and the divisional court in Hazlitt, which I don't think we've had in the bundle, but the reference here is all I need, where the divisional court held that where the paying party had raised a genuine issue as to whether or not the litigant had properly incurred costs in the proceedings, the litigant would be at risk if he failed to support the presumption by the production of documents. And in my submission, one could apply a similar procedural approach to the issue that my Lord is concerned with. If the paying party raised a genuine issue that the real loss was suffered in a currency other than sterling, then by definition, once a genuine issue has been identified, and that will be subject of whatever material there is that the paying party has to support it, the court then can proceed to determine whether or not to proceed and determine the issue. But it's a filter. The court would take into account the costs, the proportionality of the exercise. Obviously, I mean, this issue isn't going to be, if it's thought, isn't going to implicate every single case that passes through the costs office in commercial litigation. Of that, one ought to have some confidence. My Lords, I've dealt with the policy points very, very quickly in answer to my Lord's questions about fixed costs and cost capping. Of course, cost capping is a discretion. If the court was persuaded that there was a genuine issue about currency and the appropriate order that the court will make in respect of costs down the line, then it could simply not exercise its discretion to cap the costs. The point is, none of these points which have been developed by my learned friends in relation to practicality, proportionality and policy cause the court, in my submission, to deviate from the principle where it's appropriate in the right case, where the loss has been suffered in a foreign currency, that the judgment on costs should reflect that.
Tell me, if a litigant challenges his own solicitor's costs,
yes,
and puts that to taxation, are those assessed in sterling, irrespective of whatever agreement has been entered into between the solicitor and the client? So, for instance, the solicitor and the client could say, the solicitor could say, I want to be paid in US dollars, and the client could agree to that. But then, if it comes to taxation of
yes,
those costs, are those all assessed in sterling?
Yes, I'm speaking entirely for myself. I'm not aware of any case, actually, where a court has assessed a costs in a currency other than sterling. There are examples of cases where sterling has been converted to reflect the loss, the currency that was the subject of the retainer, but it presents difficulties from a practical point of view for a cost judge to be expected to assess costs in a currency other than sterling, where his whole experience...
The ultimate liability of the client doesn't depend upon his contract. It depends upon what is assessed by the taxing master as the liability. Is that correct?
Well, it's partly correct. Obviously, what the cost judge assesses as the liability can't exceed the client's liability. So the client's liability is relevant.
The client enters into a contract with the solicitor. The solicitor presents a bill.
Yes.
The client then says, no, I'm not going to pay that. That's far too much. And that's then all assessed in sterling. It's
assessed in sterling, but if the liability on a solicitor and client, I've not had the situation arise, but if the facts were the liability is in euros or US dollars or whatever it was, and that is the currency of loss, then the cost judge would could issue a certificate in euros or US dollars, whatever it is, having converted the sterling assessment to equate to the appropriate conversion at the date of the costs were discharged. But it would assess the costs in the sense that it would undertake the mechanics of what is a reasonable sum to allow by reference to the judge's experience in sterling, because otherwise it's a very difficult task. I hope that's helpful, my lords. Really.
And just in the area of cost capping.
Yes.
So a sterling cap is fixed. So whatever thereafter happens, even if the court thinks that the cost should be paid in a different currency and so on, they can never exceed the sterling cap, presumably.
Well, that's
how would that work?
That's right at one level, but sorry to interrupt you.
No, I mean,
that is right.
How it does work.
Well, first of all, as I say, in advance of deciding whether or not to cap the costs, the court would, if you're going to raise a point about the appropriate currency in which the cost should be capped, then that would be a precursor to any cost capping exercise, and the judge is likely to say, well, if there's going to be an argument about the nature of the currency, I'm simply not going to cap these costs. It is a discretion.
Why wouldn't the judge say, I mean, this case in the Patents County Court, which is going to last no more than 2 days, should not cost more than £X, and I'm going to impose that. The fact that there may be subsequent arguments about currencies and so on, why should... Let's assume the judge hears that and says, no, I'm still going to cap the costs. Speaking for myself, I would have thought it would be entirely reasonable for him to do.
I don't disagree that the court can do that.
So and likely would, particularly in a planning context where the Aarhus Convention applies.
Yes, I wasn't seeking to say that the judge wouldn't do it at all.
How it works then.
Yes.
So the judge fixes caps the costs at £100,000.
Yes.
And then there's an argument about whether it should be in a foreign currency. If you translate relevant figure, it's equivalent to £150,000. I mean, presumably the cap still applies. The paying party pays 100,000.
The cap would still apply. These are, in one sense, an exception to the rule, but it's not a. It doesn't dictate the answer to my lord's the issues before the court. I mean, I accept it rather falls into the similar category of fixed costs.
Yes, I see.
But
but it could arise, for example, in the Patents County Court, as I mentioned.
But it could. But even in the IPEC, where there are fixed the 60,000 and the 30,000, as my lords are aware, there is a discretion, which I was surprised to see, that even though the cost rules, the rules make it plain that they are fixed, actually there are examples of where exceptional circumstances where they've been exceeded. And I would assume there'd be an opening there for a party to say, well, I know you've capped them in a particular figure, but we have a genuine issue over the appropriate currency in which to make the cost award, which would have to be addressed. But the principal answer is I would agree with my lord's observations.
But on your argument, you could cap the costs in any currency you like. I mean, what's inhibiting a judge from imposing a cost capping order?
Well, I think it's a practical one as much as anything else, because the judge, in assessing what is the appropriate cost to cap the figure at, is going to turn to his or her own experience in assessing costs in sterling. Okay, one looks at hourly rates and all the rest of it, but it could potentially convert the sterling liability into a euro liability. There's nothing in the jurisdiction that, under Section 51 which would prevent that. Thank you,
Well, I was thinking about the jurisdictional point that Lord Richards raised earlier. I mean, the court's only power under statute is to make an order in respect of the costs of and incidental to the proceedings. The question is, what does that statutory expression mean?
Yes.
If it means the amounts for which the client has been billed by his lawyers, and those bills are in sterling, then that's what the court has jurisdiction in respect of.
Yes, agreed.
If it means the diminution, if you like, in the wealth available to the party by reason of having to pay his lawyers, whether he funded it from naira or gold or paintings or a racehorse or whatever it might be, then that's what it means.
But I'm not convinced that's the right. And I've got to give way to my learned friend, but I'm not sure that the second of those limbs is really a fair characterisation of what we're saying. I mean, ultimately, if the loss, if the receiving party's expenditure and loss in respect of its expenditure on costs is properly reflected in a foreign currency, because that is what it has spent, then there's nothing in Section 51, which we would submit, prevents the court from respecting that.
So his costs aren't to be understood as what he's paid his lawyers.
No.
His costs are to be understood as I say, some sort of loss.
Of what it's incurred.
Because if it is a jurisdictional question, then proportionality and policy and so forth don't enter into it.
Well, quite, because we would say, that the fixed cost regimes and the budgeting regimes and the cost capping regimes all come after So I entirely accept that, my lord. Thank you.
Yes. Well, Mr. Hoskins.
My lady and my lords, that leaves me to address very briefly two topics which will arise if the court agrees with us about the principle to be applied to decide when to award costs in a foreign currency. First, whether the judge, therefore, exercised his discretion on an incorrect basis, so that his decision should be set aside and remade based on the correct principle. And second, the application of the correct principle to the facts. And in that context, I'll address my learned friend's attempt to reopen the facts that were not disputed in the courts below. On the first point, the court will be familiar with the test for appealing against a discretionary decision. It's helpful, if I may, just to show you that quoted in our written case. That's at page 87 of the main bundle. As the court will know, the test is an appeal court has to be satisfied that the judge misdirected himself in principle or left relevant factors out of account or took irrelevant factors into account, or that he reached a decision that no reasonable judge properly directed could have reached. And we give the reference there to the decision in Jopling and Leasley of the Court of Appeal, which was a costs appeal. Mr. Milner has already taken the court to the judge's decision, and I won't go back to that. But in our submission, if the court agrees with us about what the correct principle is, then the judge misdirected himself in principle. He expressly rejected the principle that we have argued for, and therefore did not ask himself what we say is the correct question: in what currency was the cost ultimately felt or borne by the receiving party? Indeed, he placed no weight on that factor at all. He regarded as decisive the currency of the liability and payment. It follows in our submission that if we are right in the court's view as to the applicable principle, then the judge's decision must be set aside and retaken applying the correct principle. Turning now then to my second topic, the application of the correct principle to the facts. The first aspect I need to address here is my learned friend's attempt to raise a new issue and introduce new evidence on that issue. Again, the relevant principles will be familiar territory for the court. It's helpful to see those set out in the Promeo case. That's in the supplemental bundle at page 80, tab 2. And the key principles, the key reasoning rather, runs from 145 to 155, but given the time, if I may, I'll focus on just the final part on page 80 from page 153. This is the combined judgment of the board. There is, as Mr. Justice Snowden explained in Notting Hill, a spectrum of cases. That spectrum ranges from a case where the new point would have caused the parties to conduct the trial differently or would involve a further factual inquiry and prejudice to the opposing party, in which circumstances the principle of finality in litigation carries great weight, to a case where the new point is a pure point of law and the court can be satisfied that the opposing party will not suffer prejudice, in which the appeal court is far more likely to allow the point to be taken. See also Singh and Das. The Supreme Court has confirmed this approach in two recent judgments, Sainsbury's and FII. And then in 155, in summary, because of the principle of finality in litigation and the policy reasons which support that principle, an appellate court proceeds with great caution before it allows a new point to be taken on appeal. The court may depart from the principle of finality, as it did in Petilis and Grant, where the point is a pure point of law, and the proceedings below would not have been conducted differently if the point had been taken at first instance. It may also depart from the principle in the context of a group litigation where a point of legal principle that will affect many parties is an issue, as in FII. But the principle of finality is likely to be upheld if new evidence is needed for its determination or if the opposing party is otherwise prejudiced. And applying those principles here, it is in our submission too late to reopen the question of how Nigeria in fact paid its invoices. And there are three reasons I would briefly highlight. The first is that it is an issue on which new evidence would be needed, that is accepted. And we suggest that by itself makes it unsuitable to reintroduce this issue on an appeal, because it would involve a further factual inquiry leading to inevitable further cost and delay. Second, in our submission, it's no answer for Nigeria to say that they're not seeking to introduce new evidence before this court, but they want to have the issue remitted so it can be considered afresh at first instance, because that infringes the principle of finality just as much as if they were inviting this court to decide a new issue for itself. Indeed, if anything, it's more egregious because it requires a further separate hearing and creates the potential for a further round of appeals.
But I thought there's going to be a cost assessment anyway, so if this question did need to be determined, it could be dealt with as part of the cost judgment. I thought that's what Mr. Milner said, by the cost judge.
My lady, I understand that point. The difficulty here is that this is a point that has been addressed before the first instance judge. So it's not a point that the parties allowed to proceed to detailed assessment without making any submissions on. And at first instance, my learned friends were content to put their case only on the points of principle. There was no dispute about the facts. And indeed, that's why we've had now these 2 rounds of appeal addressing the question of what the legal principle is. So in our submission, it wouldn't be right in those circumstances to give my learned friends another bite at the cherry to raise new factual issues that were common ground in both the courts below. Because in those circumstances, this entire appeal process then would have been rendered wasteful and pointless if actually where one ends up is that the loss is found to have been felt in a different currency on different facts that haven't been raised before.
I mean, I suppose a different way of putting your point is that there was no order for this to be argued as a preliminary issue.
Quite, my lord. Yes, exactly. I mean, that is how one could have addressed it. If they'd wanted to do it in this way and be upfront about it, they could have said to Mr. Justice Knowles, well, we want to have a bifurcated approach. He might have allowed that, or he might not. He might have said, well, actually, I'd rather hear all the facts and all the law now, so that if there's a decisive factual point in Nigeria's favour, one then doesn't need to have 2 rounds of appeal in the courts above. And then my third reason is that no good explanation has been offered for why Nigeria did not take this point and introduce any evidence on it in the courts below. They could have done it at first instance, or at the very least, they could have done so in the Court of Appeal, sought permission to introduce the point at that stage. It's quite striking in my submission that there's actually been no explanation at all why Nigeria could not have taken this point at one or other level in the courts below. And so we respectfully submit that this court should not permit this attempt to reopen the facts and introduce a new point at this stage. I contend then to consider what we say are the correct legal principles as they apply to the facts that were, as I say, common ground in the courts below. In our submission, applying the Folias approach for which we contend, this is a clear case where Nigeria's loss was suffered in naira. The court, on our approach, is ultimately seeking to identify the currency in which Nigeria's loss was most truly suffered. And as the court knows, a body of case law has developed in the context of damages and other types of claim, which gives guidance as to how that test is to be applied. And we suggest that the approach laid down, in particular by the House of Lords in the Despina R, in the passage that my learned friend highlighted, applies squarely to the present case. It's worth just reminding oneself of that passage. That's at page 1121 in the bundle. It's the passage at F and G. I won't read it out again. My learned friend has already done so, but in our submission, the situation that Lord Wilberforce is addressing there applies squarely to the present case. Put shortly, it's a situation where a party generally does business in one currency, currency A, but it uses that currency to purchase a different currency, currency B, in order to incur expenditure. And in that situation, in general, the loss is suffered in currency A. The reasoning there is expressed in general terms, and Mr. Milner also went through the objections that follow and that are dealt with. And again, they're dealt with in general terms. And we suggest that that is an approach of general application in the situation that Lord Wilberforce is addressing there. And as the court knows, that principle was decisive in both the decisions before the House of Lords in that case, in both the tort and the contract claim. The same general approach was also applied in the Texaco Melbourne. I won't go to that given the time, but the key part of the reasoning is at page 1276. And again, it was a case which engaged the situation identified there by Lord Wilberforce, and the same approach was applied. And finally, in the DON as well is another example we've relied on. Again, the reference there is page 1268 to 1269. And so in my submission, wherever that situation identified in that passage has arisen, the courts have consistently applied that approach. Applying that then to the facts here, as the court knows, it was common ground below that Nigeria conducts its business principally in naira. It used naira to acquire the sterling used to pay its legal costs, and we suggest that that therefore falls squarely within that general approach identified in the Despina R and applied in the other authorities. And in our submission, that conclusion is also correct as a matter of principle and logic if one is applying the Folias approach. If Nigeria had not had to incur its reasonable and proportionate cost of these proceedings, it would not have withdrawn the relevant naira sums from its consolidated revenue fund, and it would not have exchanged those sums into sterling or paid that to its lawyers. And so an award in naira in our submission would return Nigeria to that position by replenishing the naira in its consolidated fund by the same amount of naira which it withdrew in order to pay those costs. And so Nigeria would be made whole. And in our submission, if the court agrees with us about the Folias approach in its application here, this is a clear-cut case where the expense was ultimately felt or borne by Nigeria in naira. Now, my learned friends make 2 points in response to that. The first is to say it was reasonably foreseeable that Nigeria was billed and paid in sterling. We don't need to turn it up, but that's at paragraph 76 of their written case. Now, that is true, but of course it was also reasonably foreseeable that Nigeria would acquire those sterling using naira, its national currency, and the currency in which it primarily conducts its operations. And so a test of foreseeability, to the extent one is applying that, does not rule out either currency here. The second point my learned friends make is to say that the cost assessment process will be conducted based on the sterling amounts invoiced by its lawyers. And so they say it follows that the loss was suffered in sterling. But with respect, that point would sweep away the fundamental distinction made in the Folias and the other authorities between the currency of immediate expenditure and the currency in which that expenditure is ultimately felt or borne by the claimant. One can take the Despina R as an example. The expenditure there were sums spent in various local currencies on ship repairs. And if there had been any debate about whether the claimant had failed to mitigate its loss by overpaying for the ship repairs, that would no doubt have involved assessing the market rates for repairs in each of the local places and comparing them with the actual local currency amounts the claimant had spent. But none of that would change the conclusion that the expenditure was ultimately felt by the claimant there in dollars because it generally conducted its business in dollars and it used dollars to purchase each of the local currencies. In our submission, exactly the same analysis applies here. There may well be points made about reasonableness and proportionality which involve an assessment of the sterling sums, but that does not change the conclusion that if one is applying the Folias principle, the expenditure was ultimately felt or borne in naira. And so we suggest that neither of those points really holds water, and that this is a clear-cut case on that approach where the loss was ultimately felt in naira. Unless I can assist the court further, those are my submissions.
Thank you very much, Mr. Hoskins. We're going to adjourn for a short time to consider what, if anything, we need to hear you on. We've decided that we don't require to call on the respondents. So we will give you our judgment as soon as we can.